Good morning, good morning, good morning. We're going to start, even though people are still coming into the room. If you expect to get CLE credit for this, which is the only reason I can think of for your being here, I am told you must sign in at the beginning, not at the end. So if, you see, that stirred somebody. My name is Arthur Miller. I teach law. I'm a bit of a troublemaker. And what we have for you this morning is a dialogue, not speeches. I've asked each of the members of this very distinguished panel to treat this more or less as a bull session. There's no beginning, middle, or end other than the clock. Where we go, we'll see. Let's start by having them introduce themselves. You've got an immense amount of information about them in the brochure, but visually let them each tell you who the hell they are, maybe even why they're here.
Thank you. I'm Suzette Malveaux. I'm a professor at Catholic University. I think why I'm here, I think I'm an academic. Next, of course, Arthur Miller. I teach civil rights, civil procedure, and complex litigation. And apparently there are about 88 law review articles out there about Twombly and Iqbal. Mine is one of them. So I think I'm one of these proceduralists who sort of addicted to Iqbal, I guess, and has not yet recovered. So
it's a very good article. I've honestly read it. On the other hand, I'm ashamed to admit there will be an 89th article this fall in Duke.
Yes.
Which might be worth reading too. John?
I'm John Friedman. I'm a partner in the litigation department of Arnold & Porter, and I'm here, I believe, to provide the in-the-trenches defense view of these cases.
That sounds defensive.
That's what I do for a living.
I'm Elizabeth Cabraser from San Francisco, a partner in Leaf, Cabraser, Hyman, and Bernstein, and we try our best to plead cases in civil rights and torts and antitrust and securities fraud and such like. And so our job is to charge the trenches. And I occasionally moonlight and teach complex litigation and class actions and write law review articles, but I won't be writing a law review article about Twombly or Iqbal, just as my contribution to
the plate is full, Elizabeth. Debo?
Good morning. I'm Debo Adegbile. I'm the litigation director at the NAACP Legal Defense and Educational Fund. My particular interest in this issue comes from the perspective of a civil rights litigator and access to courts. My more important claim to fame is that I was a classmate of Suzette's in civil procedure many years ago. We went to law school together.
Andy Pincus, I'm a partner in Mayor Brown's DC office, a litigator on the defense side, although maybe not, I'm an appellate lawyer, so not in the trenches, maybe one level above.
I'm Barbara Hart of Lowy Dannenberg Cohen and Hart. I'm a plaintiff's lawyer and I do complex antitrust and securities class action litigation, and I am completely unbiased and fair in everything that I say. And I'm here because I'm a middle-aged woman partner in a law firm and they needed diversity.
Should I bring the shrink in now or later?
Bring it on.
Judge?
I'm Judge Louis Sands from the Middle District of Georgia, where I sit. And why am I here? I'm here to enhance my judicial experience and common sense.
I'm Diane Sykes. I'm a circuit judge on the Court of Appeals for the Seventh Circuit in Chicago, and I think I'm here predominantly as a conservative foil, perhaps, as a George W. Bush appointee to the Seventh Circuit. Also, perhaps less self-evidently, I bring to this topic the perspective of not just a Court of Appeals judge in the federal system, but the perspective of a trial judge in the state system, like Judge Sands for many years, where I presided over about 200 jury trials, civil and criminal, and a member of my home state's Supreme Court for 5 years in Wisconsin, where we dealt with these issues and the perspective of the state experience versus the federal experience.
In the minds of some people, this is a technical subject. And I have no illusion that many of you had lousy civil procedure courses and can't stand this subject. But as this panel, I think, will develop, this is not really a technical subject. This subject has deep philosophical roots and consequences. Indeed, it even made Senator Franken's list last night. He did refer to Iqbal. Now, for those of you who had a bad civil procedure course or had one so long ago that you don't keep up with this stuff, here's a thumbnail. When the rules were promulgated in '38, the rules reflected sort of a liberal ethos of that era of easy access, move past the pleadings. All Rule 8 requires short and plain statement showing the pleader is entitled to relief. Then into discovery to mine the facts and formulate the issues. And the model of that period was trial and, when appropriate, before a jury. Well, life goes on, the earth moves. Obviously, the litigation model of the 30s is not the litigation model of the 21st century. And what we've seen in the last 25 years, Twombly Iqbal simply being a manifestation of it, which you can either demonize or simply understand as a change in society, what we have seen is basically there are no jury trials. Basically, there are no trials. One of the biggest wastes of public spaces, increasingly, are courtrooms. They're empty. What we have is a pretrial system. In '86, the court said, well, this thing called summary judgment is pretty effective. Let's use it more often, or at least that's the way the judiciary interpreted 3 cases. So the concept of the adjudication at trial started to shift toward adjudication no later than summary judgment. In the years since '86, there has been an increased pressure on the front end of the pretrial system, so that in 2007, a case reaches the court known as Twombly. It's a big antitrust case, a monstrous antitrust case, as a matter of fact. What the truth of the matter is, I'll never know, nor will you. The court chose, in that case, some would say, to redefine pleading. The court picked a word which it had used in the summary judgment context, plausibility, and imported it into the pleading structure, saying that the word showing in Rule 8 meant showing, a construction never seen before in 60 years. The court said you must show plausibility in the complaint. Now, what's plausibility? Well, Twombly didn't go much more than to say, plausibility is more than possibility, but it's not probability. Obviously, the justices had a P fixation. Well, people said, oh, that's antitrust. And really, you could say, as some courts in fact did, that case was about the substantive law of antitrust. It's just a nodule. But then came Iqbal. 2 years later, 13 months ago, Iqbal took Twombly and generalized and made it the across-the-board pleading standard for all cases. It was a case that grew out of 9/11, charges of serious governmental misconduct with regard to people thought to be terrorists, but arguably were selected because of ethnicity and religion. We'll never know. The court not only said plausibility is a universal requirement, but it said you determine plausibility just the way Judge Sands described it a few minutes ago. A judge is supposed to use his or her common sense and judicial experience. Common sense and judicial experience, two concepts never seen before, at least in formal opinions, regarding pleading. There's also a strong element in Iqbal about an obligation to look for an innocent explanation for the defendant's conduct that might be more likely than the charged misadventure. Now, the question is, what the hell does all that mean? And who cares? It's all about words, plausibility, judicial experience, common sense, more likely. Elizabeth, did I wake you up?
No, it just frightened me a bit.
Has your life changed since, as she would say, Twigball?
When I'm paying attention to what I'm doing, sure, it's changed. We spend a lot more time with the pleadings that we craft. We always spend a lot of time. We never like to face motions to dismiss, even plausible motions to dismiss. So it's not as if, for the first time, we have to think about what we're writing when we write a complaint. We spend a lot more time, and I will say that we do reject some cases that we believe do have merit, because the truth is implausible on its face. You know, history is just one implausible thing after another. And sometimes what happens to people is implausible too. The victims of the Bernie Madoff fraud, that was kind of an implausible thing to think about before it was revealed. So it has had an impact, probably more on my clients and potential clients than on our law firm, because unfortunately, there's enough plausible wrongdoing and fraud to go around to keep litigation moving. But it's the cases that the public never learns about, the judicial system never learns about, never has a chance really to apply that judicial experience and common sense when it matters, which is past the pleading stage, when we are sifting the facts that have been adduced.
So you're worried about the cases that are not brought, that are, I'll use the word, intimidated by Twigball.
That are intimidated out of existence in the form of pleading, and the cases that can and should survive past the pleading stage that are dismissed. And those are the ones you read about in the published decisions after Twombly and Iqbal.
I also heard you say that, in fact, yours is a great, great firm, that the people in your firm did have sort of a plausibility standard before the two cases.
We had a straight face and social utility standard that we always applied to cases. We had to be able to plead it and advocate for it with a straight face, and it had to matter to somebody.
Is straight face, playing the word game, is straight face closer to possibility or plausibility?
Well, of course, I don't have a straight face, period. But it's about being able to urge a version of the facts with integrity because of an internal belief that at some point you can demonstrate this, however implausible on its face it might be, this actually happened and it was wrong.
Mm-hmm. And you had to comply with Rule 11.
Yes, which is perfectly effective, I think, to keep the unmeritorious, to keep the trash out of the system. It works.
Now, let's try context, a little bit of context. One thing that's very clear from Iqbal is that these decisions are contextual decisions. Your context, you're a civil rights type. Elizabeth is, and I don't mean anything pejorative, Elizabeth is a green goods lawyer. You're a civil liberties lawyer. Has it affected you and your friends?
Sure, absolutely. I think one of the problems with the Twombly and Iqbal standard is that for claims of intentional discrimination, a lot of times the plaintiffs don't have access to information about, the intent of the discriminator. They don't have policy records. They don't have things that would enable them to, in fact, push the claim from possible to plausible, because we have what's really an informational asymmetry. Basically, there's unequal access to
Give me
information.
examples of the kinds of cases that pops up in.
Lily Ledbetter, I think, is a perfect example. If you think she had no idea that she was getting a paycheck that was less than her male counterparts until well after the statute of limitations had applied. And, at that point, there was a whole argument about whether or not she would be able to get the appropriate relief based on that discrimination. If you think of somebody who, let's say you have a police officer beats up somebody, and the plaintiff is obviously, they don't know the identity of that person. They know they've been beaten up, right? They can bring a Section 1983 claim, but they have no idea who that is. And some of the courts are tossing those cases out because they're saying, if you can't identify that defendant in your complaint, it doesn't meet the plausibility standard. And so that's clearly a case where you have informational asymmetry between the parties, and the plaintiff has to be able to have access to that information just to bring a complaint, and they can't meet it because of the plausibility standard.
Is that your experience?
Yes, I think it is consistent with our experience in our examination of the cases. One case that comes to mind is a case out of the city of Cleveland where a plaintiff brought a case for malicious prosecution. He was charged with a shooting. The police obtained a video that showed that he was at work. He was a janitor, and he was at work at time of the shooting, but he was held for 8 months and prosecuted. Ultimately, he was let out of jail, but then he brought a case for the malicious prosecution. And his case was dismissed under the Iqbal standard because he couldn't demonstrate that this improper conduct was part of a policy of the local police department. So it picks up on the informational asymmetry of which Suzette spoke. These cases are out there, and part of what the decision has done, what these decisions collectively have done, is they have brought an unpredictability to outcomes. One judge will see those facts and will see that the case can go forward. Another one will apply the decisions very rigorously and kick the cases out of court. That's not to say that two judges won't see the same facts in a different way in the ordinary course. But in this circumstance, where the standard expressly calls for judges to fill in the gaps with their own experience, it's an invitation to unpredictability.
That's a subtle rap that judges may see less discrimination out there than you do.
I think that that's one view that might be consistent with my view, but I am sitting up here with judges who I may one day be before, so I'm mindful that there are a lot of experiences in the judiciary, and I think that's a good thing.
I've been before Judge Sykes. Don't worry about it, Deborah. Don't worry about it. Now, John, you're in the trenches. You're a self-confessed trencher. Are these people blowing smoke?
Let me say, I think there are 2 points I'd like to respond to in what's been said. I think Twombly and Iqbal have changed at least how my clients look at these cases because they see the Supreme Court paying heed to concerns that have long been important to the defendants. In particular, Twombly's discussion about a plaintiff needing to show that they've got a plausible case before opening up the files and incurring huge amounts of defense costs. It's also made defending these cases with clients with those kinds of expectations a little bit more difficult because I think in my day-to-day life, I don't actually see these cases as having changed the standards. I'm not getting more of my motions to dismiss granted than I was before. That might have to do with my cases. That might have to do with the way courts are applying the new standards. So I have a greater challenge in terms of client counseling is how I think the cases have changed my personal practice. I also want to say...
Isn't it true you'll also just about make that 12b6 motion in every case?
I think that's fair. I mean, I think that I would be inclined, if there was a grounds to file a 12b6 motion before, to file it, recognizing that there are potential trade-offs and that you're creating bad law of the case for yourself if you lose. I think now, yes, I think I'm more likely to advise a client that given the Supreme Court's guidance on this, yes, you ought to look more seriously at filing a motion. Don't count on it being granted.
No, but at least it'll get you 6 months to 2 years.
Depending on whether the judge
And,
is
you
willing
know,
to
the
stay-
plaintiff may die, declare bankruptcy, Elizabeth may get tired of the client.
Well, the question is
Or vice
whether
versa.
the question is whether it's got a practical impact, given that many judges aren't going to stay discovery while they're considering the motion.
Now, Andy, you're an appellate lawyer, but I know you've got talents at the ground floor, too.
I guess I'd say a couple of things. I think if you look at where the lower courts were and even the Supreme Court was on pleading issues, this is much less of a sea change than it is a reconciliation of a lot of language that was out there in lower court decisions and Supreme Court decisions. I mean, really,
Which Supreme Court decision?
there was a Supreme Court decision, I knew it was going to be like law school.
This man, I kid you not, I know this man. He's a walking encyclopedia of Supreme Court jurisprudence. It's not an unfair question.
There really are two parts to the test, right? There's the part that says disregard conclusory allegations that just parrot the elements of the claim. And there was a Supreme Court decision called Papasan that basically said something pretty close to that. The second part of the decision is, okay, you've disregarded those conclusory allegations, what do you do with what's left? And there were certainly it's an antitrust case, but I think fair for this purpose, Associated General Contractors, language that said you do have to sort of make some assessment about what's going on here in terms of the inferences that you're being asked to draw. And I think if you then look from the Supreme Court to the lower courts, there were even more cases that said things like that. So
That's why you're such a great appellate lawyer, Andy. You can find a snippet in a case and magnify it beyond description.
But these were snippets that the lower courts had looked
How
at
about
too.
the snippet in a case Judge Sykes is well aware of, the Tell Labs case, which says you look at a complaint holistically.
I think
You don't exclude the conclusions because they may shed light on the factual allegations. And by the way, Andy, do you know where that line between fact and conclusion is? Is it written in the sand? That's fact, that's a conclusion? Like
Well,
the
you
word
know,
like negligence,
I
agreement,
think
conspiracy.
I guess I'd say two things. First of all, I think like all lines, and like judicial experience, judges have to exercise judgment. And that's why I don't think judges are like umpires when the Chief Justice says they are. And I don't think that this kind of question is something that as to which there is some objective truth that can be found. Judges have to exercise judgment on this issue as on everything else they do. So I don't think it's reasonable to say, just because judgment is being explicitly recognized, which is probably a good thing, rather than hiding it under the rug, this makes this test somehow unique in the world of jurisprudence. I think it's routine in the world of jurisprudence. But
Okay.
let me go on from the cases, because I think the courts of appeals had looked at many of these snippets in doing what they were doing. To the data. I mean, the Judicial Conference and the Administrative Office of U.S. Courts has been focused like a laser on what's been happening since Iqbal and Twombly were decided, and they publish actually monthly statistics about what's happening. And what the statistics really indicate is the dismissal, the rate of granting motions to dismiss is variable by month, obviously, but in the same range that it was before those cases were decided. And that actually in civil rights cases, it was 15% for the average of the 9 months before Twombly, and it was 16% for the average of the 11 months after Twombly. So I think both in terms of what the courts had said before and in terms of the data, it's hard to make the case for the sea change.
Of course, you don't touch Elizabeth's category of cases that are not brought. Can you dispute his statistical analysis?
Yeah, actually, the Federal Judicial Center.
Let's play a numbers game.
Okay,
We played a
well,
word game.
we're
Let's
gonna-
play a numbers
All right,
game.
we'll nerd out a little bit here. All right, in March, the Federal Judicial Center did interviews of about 35 attorneys, which is clearly a small sample. It was, plaintiffs and defense attorneys, and in that study, the FJC did come out and say that they had not seen the dismissal rate increase. Now, I think what's important to look at that study is that, first of all, extremely small sample size. Second of all, the dismissal rate, even if it remains the same, doesn't account for the fact that you have so many more motions of dismiss that are being filed. So certainly from a raw data point of view, you're going to have more cases that are.
This number is the number of cases, the percentage of dismissals with the denominator as the number of cases filed. So it's not the percentage of motions granted. It's actually, and it's not based on the interviews. It's based on the statistics gathered from every federal courthouse in the country.
What I think maybe we're talking about a different study, because the Federal Judicial Center is looking at something now. They're doing a comprehensive study of all the district courts within 12 circuits, and are not coming out with kind of a real quantitative, a substantial quantitative analysis until November, where they're going to present that at the advisory committee level. In terms of statistics that I've seen, they're varied. Quite frankly, I think it's a little too early to say systematically what's going on, since Twombly came out in 2007 and Iqbal in 2009. There are some law professors who have done studies that show that there is an increase in the dismissal rate for civil rights cases, for Section 1983, for employment discrimination. And so there's really some variation in terms of what the quantitative data is saying right now.
But they're just law professors.
Well, let me help you then. The judges themselves, all right, if you look at all of the appellate court opinions and district court opinions, are saying we're looking at this complaint and we are going to dismiss this complaint. If this had been Conley versus Gibson, we would not have dismissed it. So I think even the judges themselves are saying this is a different day, this is a sea change, and the dismissal rates are going up for certain types of cases.
Well, Judge, is this a different day? Is your life changed? Or how do you deal with these two cases?
Well, I think life has changed. I don't know yet whether statistically it has changed. We looked at some numbers. I think we've got to wait for a few motions to clear before we can determine whether there's a pattern to it. But I think what has changed is the fact that there is an increase in motions filed that the court has to address in a different way than it did for so long. As you well know, 12B6 motions were filed and were filed routinely and rarely granted. But now, since the court has a more involved determination and determining plausibility, it has to spend more time actually considering the matter than it may have done before, even if there's no real difference in the ultimate outcome of the dismissal. But I think, though, the real questions that I have and that I see are in the pro se cases where there's such an imbalance between the pleaders. In other words, you have someone who's well capable of filing a very fine motion to dismiss, but the pro se plaintiff may have great difficulty in even stating a claim. As you probably know, district judges spend a lot of time just trying to figure out what is it that is being pled, and where there was a burden to, in effect, make sure that you are not dismissing something where there's a possibility of a claim being made. Now the reverse question, in a sense, is being asked by way of the motion to dismiss that this is not plausible, so it should be dismissed. The other thing that makes it different too is that with a motion to dismiss is now more likely to come a motion to stay discovery. And in the 11th Circuit, you already have a very strong bias against discovery, say in the cases involving qualified immunity, those kinds of cases. So the impact of lack of discovery, lack of skill or ability in pro se cases really changes the court's role in a sense, where the court is more intensely involved in making a determination. And I think there's some imbalance there that we don't quite yet know how it's going to work out.
Do you have a feeling that you're operating more subjectively than objectively?
I think
Where do you get your common sense from? At your mother's knee, I know.
I love that. Yeah, I love that. Well, of course, I think it's probably something seen from the eye of the particular judge having it at a given time. I don't know if there's a way to objectively determine it. I don't think that alone is so much of a problem, because you're always trying to balance things and try to effect an equitable approach to a case. That itself is not so different. But in the context of that I just said, though, where you have an inability or less of ability on the part of a plaintiff who supposedly should have an ability to bring a case, should be heard in court. That's the kind of the background, as you mentioned earlier, from Rule 8. Mm-hmm. But to shift it now as to what is plausible makes it far more difficult. I also would expect there to be more requests for interlocutory appeals, since judges will be looking at these things individually. Then obviously reasonable judges could differ. So there'll be a test of review. But in reviewing, does the circuit court apply its common sense and judicial experience to my application of common sense? And so so I don't know. There's very little to guide the court, the trial court, in its decision making. So
it almost sounds like a conflicts problem. Does the appellate court apply its common sense, or is it supposed to find out what your common sense is?
Whether it was reasonable.
What do you do up there? What do you do up there?
It's A. The former rather than the latter. It's a Denovo standard of review, obviously, and so the
On the
appellate,
12b-6.
the appellate court is bringing its own common sense and practical wisdom to the problem, with great respect for the views of the learned trial judge. And that's typically how the opinion is written, but it is a de novo standard of review, and with any given appellate panel, there will be typically at least some experience in the trial court, either as a former trial judge in the state or federal system, or in private or public practice. And so there is that informational and experiential background that we're bringing to bear on these cases, and at least from my own perspective, a very healthy practical respect for the importance of the jury system based on my experience in a different sort of trenches that my colleagues on the panel here this morning bring. But having said that, I can completely understand the alarm of the plaintiff's bar, plaintiff's civil rights bar, the plaintiff's employment discrimination bar, the plaintiff's consumer fraud bar, at these decisions. It was similar to the alarm that was felt at the time of the Supreme Court's important decisions on the summary judgment standard in the 1980s, when I was a civil litigator in private practice on the defense side. We heard the same thing from opponents on that, and there was over time the development of a stable body of case law on how that standard was to be applied in the daily fare of cases that we have coming through our courts. And I think the same thing will happen with this, that eventually in each discrete discipline within the law, there will develop a body of case law about how heavy-handed this standard turns out to be, this new plausibility standard in actual practice. And I think that most judges are going to be very cautious about engaging in too early dismissals of complaints based on the new Twombly-Iqbal standard.
But as Debo pointed out, a number of cases have been dismissed post-Twombly or Twombly-Iqbal that you just know would have survived the 12b-6
Well, the Conley,
previously.
right. The Conley standard, literally speaking, was almost impossible for...
No, and Andy is right. In reality, that standard had moved, and nobody was doing anything more than mouthing the language of Conley. But with deference to Andy, he quite understandably ignored the 2002 decision in Swierkiewicz, which says 5 years before Twombly, Rule 8 is Rule 8.
Right. Well, and that's going to be a problem area for us to sort out, both as district court judges and as Court of Appeals judges. The whole idea of allegations involving state of mind now requiring some factual heft rather than the typical general allegation that the defendant acted intentionally or in willful disregard of my constitutional rights or with the purpose of discriminating. I mean, that used to suffice. It's not going to anymore. How much more is necessary will depend very much on the context and what else is in the complaint and how this plausibility standard actually shakes out over time.
Let me bug you a little bit, with respect, because I might be before you again. I may be the oldest person in the room. I wasn't there when the rules were written, but having done a little reading in civil procedure in that last half century, I have come to understand that the 12b-6 motion was a motion that was a law motion. Has there been a statement of a legally cognizable right to relief? If that was the standard, if that was the concept of the 12b-6, it's understandable that the appellate review would be de novo, because you three up there are smarter than he is. We know that. Excuse me, Judge.
No debate.
You know the law, he may not. But now, with plausibility, for heaven's sakes, we're not asking a question, does Mississippi allow damages for emotional distress without bodily contact? We're asking, could this have happened? It's not a law question. Why is that de novo review? I mean, it seems to me we got apples and oranges in the same basket now.
Well, it's the same kind of problem that presents in the criminal context when appellate courts are reviewing probable cause determinations, reasonable suspicion determinations, voluntariness of confessions, that sort of thing. And I think, we've gotten used to doing that, and over time we'll get used to doing it in this context as well.
Okay, but in that context, isn't there a bit of a record as opposed to a complaint?
That's fair, counsel.
I mean, he's got to work with one.
I stand corrected.
I'm waiting for the day. Forgive me, Judge. I'm waiting for the day in which the briefing on a 12b-6 motion goes into his common sense and goes into his judicial experience, invading his privacy. Beyond that, all you've got is a complaint. As pointed out, there's been no discovery. And under Iqbal and the 11th Circuit sort of approach you mentioned, Judge, there is a statement, Suzette will quibble with it a bit, that says no discovery until you've got an honest-to-God survivable complaint. It's a catch-22 in an information asymmetry problem. Say, Barbara, you've just been sitting there. What have you got to say about this?
Well, what I find troubling is that plausibility ends up being this power of language where it's a justification for a dismissal, even in the Iqbal case, it was manifestly plausible what was being alleged, as far as I could tell. But they determined that it wasn't plausible. And to me, one of the questions that we see is, who's an appropriate stakeholder that should at least be entitled to get answers to their questions? This gentleman that was the victim of the malicious prosecution, as far as I'm concerned, the judge should have made the answer come out as to whether they knew they had the videotape at the time and why they didn't vindicate his rights. It's a discrete question. Get to the bottom of it. And my concern with that is that what I'm talking about is more of judicial discretion, and I'm troubled by more judicial discretion. But I find that this standard is so infected with credibility determinations, common sense, and I almost view them as macro docket management decisions, that there was a desire to have more cases dead in the water right at the outset and be able to get them back out, just get them, have that issue happen. We represent, I worry about the disparity of this standard being across the board in civil rights litigation and discrimination litigation, victims' rights, and then in my situation where I represent sophisticated institutional investors, pension funds. But even in my litigation, there's such a disparity in information. The Financial Crisis Investigation Committee that's currently investigating why we're in this bedlam of financial distress is calling people before it and asking questions and making them produce documents. And the chairman of that committee, Phil Angelides, says that he's shocked and appalled that Goldman Sachs ran the clock on them and then did a huge document dump in order to bury them in minutia, and that he finds it appalling and abusive. And we're lucky, as major shareholders, pension funds, how people are going to live out their lives, we're lucky to get an answer at all. If we say, well, what happened here? We're precluded from asking the question, and we don't know what was in the defendant's mind because we have no access to information. So the asymmetry of information is a problem for us. We have more resources, but so I am troubled that I don't want more discretion because I'm troubled by these credibility determinations, but I almost wish the judiciary could say, let's let them ask these discrete. This guy was a citizen of the city of Detroit? Cleveland, forgive me. Didn't he have the right to ask a couple questions of his police force and get actual answers? He's a stakeholder, he's a taxpayer. He has a right, and the judge should have let him get discrete answers to those questions. And there should be some balancing that it's a legitimate question. It's a legitimate question. What did they know when they kept him incarcerated?
All right. I don't want to speak for John or Andy on this, but I assume they would say that's the camel's nose under the tent, that from the perspective of their clients, the clock is running, the meter is running.
It's the taxpayer's tent. As a shareholder investor, Goldman Sachs is the shareholder's corporation. You took my money. It's a public corporation. You took my money to grow that company. Answer my questions.
I guess.
Clear the first hurdle.
Clear the first hurdle.
Well, I'd say something else. The civil litigation system is not the only mechanism that exists for people to get their questions answered.
Do you think he had other recourse?
I would believe that in the city of Cleveland, there is some kind of a police review board or ombudsman. I'd be shocked if there wasn't. I would be, is there, well, I don't know. I know in D.C. and New York, the two cities I know about, there actually are remedies that are not perfect, but that do exist.
But
And
Andy,
certainly
you're
in the,
comfortable closing the courthouse door to somebody on these
well,
facts?
I'm not saying that the courthouse door is closed yet, but there are two
they're closed to
questions.
him.
Well, I assume he's appealing. No?
I'm not sure.
Well,
Who's
there are two things to say. First of all, as I say, I don't want to go back to the data, but the data does say that so far at least, the numbers do not indicate a dramatic change. I'm sure there are individual cases. There are lots of areas of the law where there's a new Supreme Court standard and lots of sorting out happens, and that's just the way the system works, and it's it's bad for the individuals, but I think there is a sorting out process, and we're going to find out, as the judge said, that, you know, there is going to be a smoothing out of the system, and my guess is that the drama that a lot of defendants think has happened and a lot of people on the plaintiff side think has happened is not going to exist, and there's going to be some incremental change in the reality when the dust settles. But I do think it's important to note that there are other mechanisms, and I hate to say it as a lawyer, but the civil liability system as it is now structured is not the best engine for finding the truth. It shouldn't be gotten rid of, but there are...
Oh, that's a concession.
No, but if
Let's
you want
not lock the courthouse
Well, I want to
doors.
say that because
Can
I don't
quote
want to
you
be
on that,
accused,
Andy?
I don't want to be a courthouse door slamming person, but if we want to
Just,
step
just
away...
another brick in the wall.
No, if you want to step away from the sort of the law and what's happening to the policy, there is a real question about electronic discovery and the burdens that it imposes once you get past motions to dismiss. Is that animating what happened? I don't know. But the reality is that if you had a system where judges were willing to say, you get to answer and closely supervise it and say, yes, you can ask these two questions, that's it. You can impose, zero cost, and then we'll see where we are. We would have a different world. The reality is judges don't have time to do that. Yeah, I think there would be a lot to be said for that.
I want to
But-
amplify two things Andy said. First, I want to put a little bit of meat on the statistics he's been talking about because I'm familiar with them as well. The administrative office of the U.S. courts has been, as Andy said, looking at this issue, studying it since these decisions first came out. And their statistics show that in any given month leading up to Twombly, 10 to 15% of complaints were dismissed, meaning plaintiff can't proceed further on a 12b6 motion. That rate remained the same after Twombly, 10 to 15%. That rate remained the same after Iqbal in the few months that they've had to study post-Iqbal. They're obviously still looking at this, but their conclusion, interim conclusion based on the statistics to date, is that they have not had the kind of sea change effect you would have predicted.
Now, you would acknowledge, though, John, this is very preliminary stuff.
I think the post-Iqbal, yeah, I mean, they
Clearly.
looked at five months post-Iqbal.
Now, I used to be a reporter for the Federal Rules Advisory Committee, and our estimate was, back in the primitive 70s, was that no procedural change really took roots for close to 10 years.
Well, let me talk
And
about
let me point out something that our Court of Appeals representative noted. I think you acknowledged that this plausibility standard is a heavier pleading burden than Swierkiewicz, let's say, because Conley is just gibberish at this point. So when you say, my God, it'll all settle out, with that great confidence you have that life will be beautiful, you know damn well it's going to settle out with the dismissal point moved
let me talk
in
about
your
a
direction.
little bit about the last great pleading reform we had, which was the reform of the pleading standards in the securities field in the mid-90s.
You use the word great, John? You could
Great
get into a
great.
fist fight with that. You think it was great?
Yeah, I don't want to.
You think it was manna from heaven?
The last change. We've got 15 years of experience under these reform, what was called the Reform Act.
And a financial crisis.
And a financial crisis and an IPO tech.
And Enron and WorldCom and... But go ahead.
This just
Courts-
goes to show
courts-
the knock-on effects of pleading reform.
Courts have not dismissed more cases prior to the statute than they have after the statute. The defense bar was very excited about this. Defense bar filed a lot of motions. More motions weren't granted. What we find is that, as Liz suggested, The plaintiff's bar has risen to the challenge of the pleading burden and is doing a better job investigating complaints. So we see the advent of confidential witnesses, our clients' employees who...
Isn't that wonderful? He's talking about tele-labs
You know what they
and
do
all
with
that.
confidential witnesses now? The judges actually do a credibility assessment about whether the confidential witness was in the room, has the basis for the knowledge, and is a credible confidential witness. And the confidential witnesses are needing to be identified in the pleading so that you have a chilling effect on the willingness of confidential witnesses to come forward. So I was there when confidential witnesses were like first put into some of these securities pleading, and we fought tooth and nail not to have to divulge the identities of them. And of course, a person's has a right to know the identity of their accuser. So the swing goes to identifying the confidential witness. That's the trenches. So when you're on the phone with the former employee who hasn't been with the company for 5 years, who in order to get their exit package had to sign a confidentiality agreement, and they say, well, will I have to pay them the money back, and will you have to identify me, and you have to tell them the truth, they then hang up the phone on you. And so, it's not a level playing field at all, and the shareholders own that company, and they're not entitled to the answers to the questions.
Liz?
I think this goes way beyond the statistics, and it goes way beyond one side or both sides whining about who has to work harder and spend more money. And it goes beyond concern about judicial common sense and experience. I think the average judge, and all judges are above average, is at least as good a judge of facts and an applier of common sense, and I think judicial experience helps in that regard. So it's not a question of confidence in judges. If none of us had confidence in judges, we wouldn't be here. We wouldn't have devoted our lives to bringing our clients' problems to judges. The problem is that it's a profound sea change that is going to, over the years and generations, affect access to justice because it further shifts. It is another brick in the wall. It's incremental. It further shifts the fact-finding role from juries, and they do exist, and in fact, jury trials are on the upswing, to judges. And it would be as if we could ask a jury to return a verdict after the opening statement in a case, before there had been any hearing or sifting or demonstration of evidence pro and con. And it's worse than that, because you can't even talk about some of that evidence at the pleading stage of a case. And so it's not only who's making the decision, it shifted. We didn't fight a war with Great Britain over the right to judge trials. We fought it over the right to jury trials. So we've sealed the fate of jury trials. We've shifted that role to judges. Summary judgment, yeah, we were upset about it at the time. We've learned to live with it because when judges make those decisions that there aren't any material issues of fact, they at least have the facts. They don't have the facts under this standard, and they're supposed to judge plausibility when we all know that the things that do happen are frequently the least plausible and least likely things to happen. If it's now rational, and I learned from the plenary session that it is rational to worry about asteroids colliding with the Earth, and, at least in the Seventh Circuit, which is the most rational of circuits, I'd like to be able to plead a case of something that's even more plausible than that and have it survive this motion and get to the fact-finding stage and get to a jury whose collective fact-finding common sense and experience we all believe is a matter of constitutional doctrine is, in the long haul, even more reliable than that of one or three judges.
Yeah, but that's in the Seventh Amendment. It's not the First Amendment. It's only the Seventh Amendment.
I know. I'm an analog person. I'm not digital. I tend to think of the Constitution holistically.
Holistically?
Yeah.
No, that
Sorry.
that word's canonically banned. Andy?
Well, I was just going to sort of step away from this and look at the big picture the way Elizabeth has. The problem is that we have a system right now that is too expensive. It is too expensive and difficult a dispute resolution system. Because the cost, and unfortunately, those expenses are quite disparate in terms of the cost for initiating versus the cost for responding. And I'm not a fan of the English rule, but I think lawyers have not done a very good job of thinking creatively about other ways to get to the truth that are more efficient, more focused, and quicker and less costly. And I think the big picture is, this may or may not be a response to the fact that, the sad fact is for defendants in, a medium-sized reasonable case, it's $2.5 or $3 million for electronic discovery.
In
It's
what
a lot
percentage
money.
of the cases? You're the big maven on the AO's statistics.
Well,
what did
I
the
wish-
study for the Duke conference show about costs?
I don't know. I haven't read that.
Ooh, I caught him unprepared. Andy, it sort of showed, and again, I hate statistics, but it's there.
Yeah.
1.5% to 3.6% of stake.
Okay, well, I don't...
What's a real estate commission? Huh? You're talking peanuts, and you're talking about it in less than 10% of the cases, but Iqbal speaks to 100% of the cases.
Well, and maybe a problem with our system is that we don't distinguish among categories of cases and create different, maybe more appropriate rules for some than for others. But that's, I think, part of the, as I say, let me just say on statistics, I've seen some studies, maybe they're a different set of cases, but of cases involving not Fortune 500 companies, but reasonable-sized companies where the number is 600,000 to 3.5 million.
Yes, that is true. But again, stepping back, what percentage of the federal docket does that reflect? Was it necessary to change the pleading rule across the board? In other words, let me phrase that differently. Some people say that Twombly Iqbal were not necessary, that if cost were the issue, and dirty little secret here, Andy, as you well know, what Twombly Iqbal does is shift cost from the defendant to the plaintiff, because the plaintiff now has to do more pre-institution to live. What Twombly...
Although if the complaint survives, the defendant has to bear those same costs. So I don't know that there's a shift that just puts more of a burden on the plaintiff.
Do inquiries into confidential witnesses, that's a free good, isn't
No,
it?
I admit it costs money.
No, nothing's free.
Nothing's free. Nothing's free, not even this panel.
The cost issue, I mean, I think it's ironic that what was happening in Iqbal and Twombly is the Supreme Court is trying to reduce cost, right, for discovery. And what's happened, again, going back to the stats, right, if you look at the Federal Judicial Center, the study says that what lawyers are experiencing are greater costs because you're going from filing supposedly frivolous complaints to frivolous 12b6 motions. And there's a cost that's associated with that. And even if you prevail, it gets appealed. So now we have this cost shifting that we haven't solved the problem. We still have a big cost problem.
I think it is a blunt weapon, but I think the problem is we have not, it's a way of dealing with what is a real problem. Again, to the extent it has a real change, and I don't think we know yet what the change is, but I'm sorry.
I mean, the Supreme Court was worried about cost. It's the rationale. But, if you want to reduce costs, particularly in complex litigation, which is the most expensive, it seems silly to say it, but, ask a plaintiff's lawyer, because we pay those costs up front, and we pay them on a contingent basis. We don't charge them to our clients. And if we lose, we're stuck with the bill. So we can't pass on those costs. We're acutely aware of costs. We do cost-benefit analyses all the time, and we litigate on budgets. And so much of the expense of this complex litigation discovery that everybody complains about, I complain about it, my defense colleagues complain about it, could be reduced or eliminated through cooperation, which wouldn't affect anybody's rights to privilege or work product. For example, why is each side paying separately for the translation of foreign language documents? It happens all the time. You can't get people to agree to share translation costs, to share translation. These are very simple things. You would think they are commonsensical things. I think oftentimes judges, in the exercise of their common sense, assume we're all doing it, but we're not. And somebody's clients are paying for it up front, and somebody else's clients or somebody else on the other side is paying for it on the back end. You could probably reduce costs 75 to 80% in most complex litigation without having to have changed pleading standards or shifted gatekeeping, gate-slamming fact-finding from a group of fact-finders to a judge at the outset.
Now, what do you make
But I'm just whining.
on an allied, closely allied point? What do you make of Justice Souter's remarks in Twombly about judicial management? Now, when it was suggested to him, and in Twombly, plaintiffs, lawyers said, just give us what he called flashlight or pinpoint discovery, those few questions, those couple of depositions. Justice Souter said,
My recollection was it was a statement that indicated an interesting view of what judicial management is, does, and should be that doesn't necessarily coincide with the experience of those of us in the trenches. So
he said it was modest.
And it's not, and it shouldn't be. So that was what was puzzling, I think, to all of us.
I can't resist.
Had a
The only
disconnect.
thing he relied on was a law review article written by her colleague before he was a judge, when he was a mere professor, ignoring 25 years of development under the Manual for Complex Litigation. I mean, some people would argue that pinpoint or flashlight discovery, cooperation, judicial management, why did they have to do this? You're the one who, I think in note, said anything that destabilizes the way these cases have destabilized, not simply Rule 8A2, but 12B6. And without boring these people to death, this funny little question, which I think is whimsical because I'm perverted. Shouldn't Twombly Iqbal apply to affirmative defenses, which are systematically alleged in the most conclusory fashion?
And as to which defendants have the burden of proof, I think they should. There's some cases that say they do, but it's unsettled.
It's unclear.
And this whole, plaintiffs,
Oh, good luck.
Oh, you woke up. Go ahead.
But I didn't mean to interrupt Elizabeth.
Go ahead.
No, you can't, when the defendants lodge an answer and the affirmative defense, it is boilerplate, it's unresponsive, it's a dodge, it's just another bucket of quicksand for you to try to get through, and you then say, okay, you have to strike that answer as unresponsive, once you finally get past the motion to dismiss, and it's just then they throw a bucket of tax. You don't get answers, you get evasion. That's what's stunning about these commissions, is that they actually put people up on a dais like this, get them to swear in, and answer questions in front of a bunch of cameras. We never get that. We don't get that. The depositions are evasion. So it's the idea, I would love that. An affirmative defense where they have the same pleading standard on the affirmative defense, wonderful idea. Never going to happen.
Oh, it'll happen, perhaps, if there's any sense of symmetry in the Rules Advisory Committee. But, as Stevens points out in dissent, defendant never has to answer. Hi, here's my complaint. Sorry, you die on the 12B6. We're going home. We don't have to answer.
But it's not like we never get past the 12B6. It's just that it's so far from done then. The class certification inquiry is now a fact-intensive, merits-laden inquiry where credibility determinations and all kinds of things. So the battlefield, the larger culture war, is lost at every turn right now.
But you don't feel strongly about it.
I do.
Just for those of you who have got a copy of Suzette's article, correct me if I'm wrong, she uses a couple of words that I think are just dead on, front-loading.
Yes.
Front-loading. The system now is front-loaded. It's not simply Twombly Iqbal, the 12b-6, it's Daubert, it's class certification, and all the rest. It's completely front-loaded.
So stakeholders don't get to ask appropriate questions.
So what would you do? Come on, solve the problems of the Western world. You can do it in the next 3 minutes, Barbara.
I like the idea of active judicial oversight on eliciting actual answers to appropriately narrow questions where a plausible, and I actually mean plausible. Plausible is not a dirty word to me. But if it states a proper inquiry that someone should get an answer to, the question should be answered. This man was entitled to an answer. And my concern about that is, with all due respect, is my experience with magistrates overseeing discovery is it's just another trench warfare that's intended to slow you down. And the magistrates don't actually, I'm really being inappropriate. I would love to see a more effective outcome from the oversight, and that's not been my personal experience, with all due respect.
And you have nobody in mind, of course.
Nobody.
Well, I love it, I love it. First we've got the defendants worrying about their costs and expenses. So let's pass it off to the plaintiffs under Twombly Iqbal. Let's solve Twombly Iqbal now by passing the cost back to the judicial officer in terms of his or her time investment.
But
It's lovely. It's a perfect system.
But to have real management, there has to be investment. You have to, this is not my
Touche,
area of expertise,
absolutely right.
but you've got to learn about the case. And if the resources are not really there now for people to make the investment, to learn about the case, and then to frankly feel empowered to make a rough cut. Because you know what it is? If our system would work so much better if somebody could say, I'm going to make a rough cut here. And, we're going to get past it, and so maybe this isn't 100% of everything you're entitled to under the rules, but we can get there by giving you,
Simple.
70%.
It's simple. Simple.
Let me
You
make a-
simply shoot every third litigant. That's the rough cut.
All right, I wanted to.
No,
I wanna
I'm
make
talking about a
proposal.
rough cut in
I know.
the case, and that's
They're not taking
No,
me
no, no, no.
seriously.
But
Andy.
I think it's an interesting. It is a fundamental as lawyers, we want to construct a system that will get at all the facts and get all the facts before the jury and have all these protections. And each incremental protection costs a lot of money.
Mm-hmm.
And if we were satisfied with rough justice, which could cut either way in a particular case, we could construct a system that would be a lot more efficient, but that's not the way we were trained, no offense, in law school. So the mindset of the participants in the system is not to think that way.
There's been a lot of talk about money, and I think some of the claims about costs of discovery are overblown. The Federal Judicial Center did a survey where the result was that most lawyers did not find that discovery was out of proportion to what was at issue in the case, and there's been a lot of studies on that. So I think it's overstated. But whether or not it's overstated, what gets lost in it is something of tremendous importance. And there is a rare passage in a district court opinion from the desegregation case in Swan v. Charlotte Mecklenburg that I think makes the point about the danger of where we are under the law. I'll read it briefly. The case was difficult. The first and greatest hurdle was the district court. The judge, who was raised on a cotton farm, which had been tended by the slave labor in his grandfather's time, started the case with the uninformed assumption that no active segregation was being practiced in the local schools, that the aim of the suit was extreme and unreasonable, and that a little bit of push was all that the Constitution needed. He goes on to say that after reams of evidence, right, not his experience, but after reams of evidence, they proceeded a reversal in the original attitude of the district court, right? So there is a value that is at stake in our access to courts. And I think that when we say that somebody who has been improperly arrested should look for recourse before a police review board instead of having an opportunity to vindicate his right in a district court for abuse of police power, we are undermining the democratic principles that our courts are there to vindicate. So I'm not saying that money doesn't need to be considered. And I come with some experience as a corporate lawyer as well. I spent 7 years at Paul Weiss, so I've represented large corporations, the same type that you represent. I understand that there's a need for balance, but whether the court should have proceeded with this blunt instrument and dislodged Congress and dislodged the Rules Committee is a very serious question, and it certainly shouldn't have happened on the limited facts that it had before it.
Suzette?
I want to make a suggestion in terms of, how do we solve this problem? One of the things that I have been thinking about, and Barbara alluded to this, is the notion of pre-dismissal discovery, right? Plausibility discovery, that and I'm wondering if the judges sort of, what you think of this. If you have a situation where there's informational asymmetry between the parties, the plaintiffs cannot get access to information without discovery to sort of nudge the complaint from conceivable to plausible, then I think what could happen is a judge could simply defer ruling on the 12b6 motion and have that plaintiff go forth and get specific facts that deal with, sort of targeted, limited discovery that go to what would nudge the complaint from conceivable to plausible, have that complaint amended at that point, and then the judge can come back and review the 12b6 motion again once the plaintiff comes forward. And what I'm not proposing is a fishing expedition where you just let the plaintiff sort of go amok. You might even say to the plaintiff, you need to come forward and explain why it was you weren't able to get these specific facts pre-suit investigation. What do you need, and how can you nudge that complaint over? I think that this could be a workable solution. I shared it with a judge the first time I talked about it, said that this was impossible and said that that's never going to work. And then I thought, well, that's a great law review article then. After that, I talked to another judge who said it was already happening. So it seems to me that this idea is somewhere between impossible and obvious. And I think it's a modest proposal where the court can, exactly.
I've had cases where
Exactly.
a judge clearly has the power to order that.
Yes.
And I've had cases where a judge has ordered that.
Yeah,
Right.
it doesn't violate the passage in Iqbal because the 12b6 has not been decided. It's a little bit of a
Right.
circumvention, but who cares?
Right. I
Who
mean, you have to
cares? Who cares?
creatively, I think, read the Iqbal language to get around it, but I don't think it's a foregone conclusion that you can't have some limited targeted discovery pre-dismissal to try to balance out, I think what Debo was talking about, the whole value system, right? We look at Rule 1. Rule 1 requires that judges administer the rules and interpret them in a way that balances efficiency on the one hand and justice on the other. And it seems like that balance has shifted, and we're not sufficiently looking at the justice piece of those two requirements.
Okay, before we go to the audience, let me just drop a footnote to what Debo just said. We have a system of regulation in this country. We know all about it. We can recite the alphabet and all that. But we also have a parallel system of private enforcement of public rights. It's not simply a civil rights phenomenon. The private enforcement of the securities laws, the private enforcement of the antitrust laws are part of that acceptance of the proposition that private litigation, even though it may be entrepreneurial, I mean, making money in this country is not really an evil, private enforcement of public policy is a good adjunct to the official regulatory structure, whether it's the SEC or the Mineral Management Service. And think about the Gulf and a whole variety of contexts in which we do rely on private enforcement as an adjunct. If you restrict or compromise or inhibit access inevitably that's going to have an impact on private enforcement of public policy, whether it's the areas you love, civil rights, employment discrimination, et cetera, or whether it's the kind of case that Elizabeth practices and Barbara practices in the securities commercial environment. Nowhere in the two opinions do you find any acknowledgement of the reciprocating effect of what they were doing. The preoccupation is solely about cost. And when you ask yourself, whose cost are they worried about? It's defendants' cost. They're not worrying about plaintiffs' cost. They're not worrying about the cost in social value of what Elizabeth started us with, the case that cannot be brought because of the pleading barrier, despite its potential merit. To me, that's the big picture. That's the big picture. Okay, it's your time. Who wants to throw a rock?
Andy Pinkett mentioned, of course, there are two aspects of Twombly and Iqbal. The first was disregarding conclusory allegations. There's been very little concern expressed with that aspect of Twombly and Iqbal. Almost all the discussion today is focused on concern with the plausibility requirement. But if the first requirement is not terribly controversial, it's high time that the ACS and other minded people extended that requirement to criminal proceedings from civil. Twombly itself was a case under a criminal statute, and it would be anomalous if a complaint, which is too conclusory to withstand a civil motion to dismiss, could be held sufficient in a criminal case where the rules of pleading are supposed to be stricter and where the rule itself requires pleading of essential facts. So I'd urge, and I'd welcome the panelists' reaction to this, I'd urge ACS to seek the extension of the Twombly-Iqbal rule disregarding conclusory pleading to criminal cases which are full of conclusory pleading. The Supreme Court has repeatedly said it's usually sufficient, not always, but usually sufficient for an indictment just to copy the words of the criminal statute, conclusory pleading. Occasionally they say that's not enough. Well, in light of Twombly, maybe it should not be enough in far more criminal cases, and I'd like to see the ACS criminal arm tackle that problem in addition to this panel.
Reaction?
It's because it's the government.
I think if the plaintiff's bar is frustrated with lack of access to defendants' files, wearing my hat as an occasional criminal defense lawyer, trying to get information out of the government about the basis for the charges is nothing in comparison. Grand jury secrecy, Rule 6E, the government is never going to agree that they need to reduce the burden. What's necessary to allege?
So should the court require them to put forth more facts in the pleadings instead of a conclusory indictment?
We actually have faith in our government.
We have the Sixth Amendment that says they're entitled to know the particulars of the charge against them.
Barbara, are you talking about the government of the state of New York, which has been wholly absent?
How about South Carolina? You want to go with South Carolina?
Okay, who else? Comments, observations, questions? We got a lot of talent here. Use it. I'm going to get the mic over there.
I'm pretty loud. I think I just want to highlight that we're focused a lot on these statistics, and there are competing statistics, but the statistic we will never know is which cases Leif Cabraser doesn't bring, which cases Barbara Hart doesn't bring. Those will not be a part of the evaluation of how many cases get, kicked out at 12b-6, because they're not being brought. That's the problem.
There's plenty to do.
I
But I don't mean to be flippant about your point. I think that's right, and I would. One of the problems in private practice, of course, is that oftentimes it's also about the economics of what the proposition is. So I can't vindicate the public good. That's not what I can do in my role. So I think what you're saying is true, but a lot of our gatekeeping or intake evaluation, social good, I was delighted to hear Elizabeth say that. I like to think that what I do is about deciding whether there's social good. I also make economic decisions at the outset. But your point is well taken, but part of that is just, I can't represent this guy who was in jail for 8 months. It's not on my to-do list, but I know he should have answers to his questions.
I think we actually agree, because I think the point is that you have to make those economic decisions every day, and you had to make them before Iqbal and Twombly, but now there are fewer cases that you can choose to take because there are more implausible cases that will never survive.
Yeah, and I think what will be measurable within the next few years statistically is how much the added hurdles of Twombly-Iqbal cost each of our clients in cases in which we are successful. Of course, if we're not successful in the case, they don't pay. That's great for them. But when they are successful, there's an additional tax that's been imposed on that success. We have to spend more time and money. I can tell you statistically, we face a motion to dismiss that cites and discusses Twombly and Iqbal in 100% of every case, of all the cases that we do bring today, whether the case has anything to do with antitrust or civil rights or liberties. We face it, and we spend pages and pages explaining, Twombly and Iqbal, and of course the judges have to deal with it, whether it should be dealt with or not. I would have a more modest proposal than extending Twombly and Iqbal standards to criminal proceedings, because I don't know enough about them. I would say that Twombly and Iqbal plausibility standards ought to be applied by regulatory agencies. So, for example, a contingency plan about dealing with an oil spill would have to pass the plausibility test, and protecting walruses in the Gulf would be a clear signal that perhaps a better plan should be on file before permits for deep sea drilling should be granted. That would save a lot of money, I think, probably.
What effect do you think these cases will have on state court cases?
100% of the cases we are filing in state court are when there are opportunities to file demurrers, which we have in California, or motions to dismiss. Twombly and Iqbal, get cited for something that the courts should consider and should impose. I mean, it's not controlling authority, but every state court judge before whom I'm currently appearing has been asked to apply those standards as instructive.
With what result? What are state courts doing when they say Arizona or South Carolina should adopt Twombly-Iqbal?
They're typically applying the existing state standards and saying that they are not inconsistent with Twombly and Iqbal. So there's some lip service that gets done. But obviously, trial-level state court judges know that they can't be changing state law standards, and they don't do it. But the record, a law record, not a fact record, is created to raise that issue in the state appellate courts. And it's it may be a fruitless exercise ultimately, but it's an expensive one.
Also, some of the questions have gone to the idea of extending or expanding Twombly and Iqbal, and Congress is considering a legislative fix, a response to those decisions. So one possibility is that they will be turned back.
What's the status of the proposed legislation?
I think that the sausage room is open and everything is very active.
In the meantime, these issues will percolate up to state Court of Appeals and state Supreme Courts as arguments for conforming the state's interpretations of their own procedural rules, which are typically patterned after the federal procedural rules, to the Supreme Court's interpretation. States don't have to do that, obviously, but the pattern in this area is to do so. In my own state, after the summary judgment decisions of the 1980s, our law was essentially conformed to that.
Exactly. There's a sickening second-level inquiry. If you've got a diversity action in a federal court in a state with a defined pleading standard that is not Twombly-Iqbal, the federal court, under the Erie complex, must apply Twombly-Iqbal in derogation of state law. Oh, well. I've often wondered when everything will be solved so I no longer have to teach procedure.
I would like to go back to Elizabeth's earlier point about the history being full of implausible events, and specifically to either the judges or Andrew and John. How does this new plausibility standard truly get to distinguishing between the frivolous claims on the one hand and those on the other hand that may or may not have merit, but because of the disparity in information, just need a little more that was once accomplished through discovery?
Well, it's pretty tough. I think some of the suggestions earlier referred to do take place. I would say I don't refer my discovery issues to the magistrate. I keep them myself because I think I need a better understanding of what's going on in the case. Oftentimes, parties are allowed to amend. We got a lot of pro se cases in federal court, and those are some of the tough cases. And you get a case that you don't know what it means, but you think there may be something to it. So you tell the plaintiff to go back and say something. Tell me what it is that you say has been done, what law it's based on, and sometimes that comes back with a different, more fuller statement. But nothing that I see now, though, really answers the question when you have the imbalance of parties. And I think some made reference to the asymmetric availability of evidence. I don't see the parties agreeing that, Judge, we need to have some pinpoint discovery. I see the defendants are saying, no, we shouldn't have discovery, Judge. You should decide this simply on the face of this complaint. That is what the case is saying. That's what you should do. And I think in cases, though, where there are plaintiffs who can lay out a strong basis of equity and reminding the court of justice, that's more likely to happen. But I think all judges are concerned, and I certainly am, to weigh in on either side. And that's why I'm a concern about the cases where there are pro se parties or where there are weaker parties to respond. Because if the court steps too far in assuring that there's discovery or assuring there are other opportunities or bites of the apple, it kind of moves the court from that position of impartiality where it wants to be sitting in the middle, hearing from both sides. So that's a concern. But I think there's room for some solutions to the problem, and some of those have been suggested.
All right, panel. Andrew?
I just wanted to make one response and a pitch for another ACS project. I think this is why it's really important who's nominated and who's confirmed in the federal judiciary, and it's really important for this administration to nominate and confirm judges who are going to be concerned about just these things. And so when they exercise the discretion that they have, as I said before, on this and a zillion other issues, they're exercising that discretion in view of a life experience and a concern about justice that is going to animate what they do.
You want to be a judge?
No, thank you.
Figured. It figured. Okay, panel time is over, but as you know, networking time has begun. So you're free to attack anyone on the panel you wish to attack.